Well, hi everybody. Last night I was watching a video by Prof. MTH about the decision by the federal court in California to overturn Proposition 8, declaring it to be unconstitutional according to the 14th Amendment. In his video description, he linked the actual decision, which is some 136 pages long. I read most of the actual decision, and I'm going to read a lot of it to you right now, as a matter of fact. Um, so this video might seem a bit dry because I will be reading, and I apologize for that. I don't have time to put together some kind of fancy graphics and shit like that. So do forgive me, but I think this is really important because the language they use in this decision um, pretty much is, bulletproof. The language they use, we've had all these arguments on YouTube, back and forth with people who oppose same-sex marriage, and those of us who are in favor of equal rights have been arguing about this ever since and before I'm sure I ever started making videos on YouTube. So all the arguments are addressed more or less here, and the best part is they're just there's it's pretty damn. I just can't see how anybody could really argue with this. It's perfectly straightforward and logical, and the best part is it's legal and it's according to the Constitution and precedents in law. Now, speaking of precedents in law, because of the way this was written, what I've done here to spare people, if you're interested in the text but don't want to go through it because legalese can be a bit dry. There's all these interruptions with different court cases that they're referring to, past precedents and all that kind of thing. So what I've done is I've sort of edited all that stuff out as far as the court cases, the names of the cases and the years and whatever that were being referred to. But where they're quoting other precedents and stuff in previous court cases or in legislation or in the Constitution, I will use quotations like that to distinguish a new bit of previous legislation or court decision which is being, quoted. All right. So here we go, because this is going to take a while, and I'm sorry if this turns into a long video or two long videos, but this is really, really good stuff here, and I think it's worth getting the language as it is rather than having it summarized somewhere on YouTube. It should be, pretty much read out. So here we go. Okay, let's just make sure we're clear that the plaintiffs are those who are in favor of same-sex marriage, and the proponents, which is the term used here for Proposition 8, are those who oppose same-sex marriage. Okay, so that's where we are in the language. Here we go with the start of the decision and the conclusion. Plaintiffs challenge Proposition 8 under the Due Process and Equal Protection Clauses of the 14th Amendment. Each challenge is independently meritorious, as Proposition 8 both unconstitutionally burdens the exercise of the fundamental right to marry and creates an irrational classification on the basis of sexual orientation. The Due Process Clause provides that no state shall deprive any person of life, liberty, or property without due process of law. U.S. Constitutional Amendment 14. Due process protects individuals against arbitrary governmental intrusion into life, liberty, or property. When legislation burdens the exercise of a right deemed to be fundamental, the government must show that the intrusion withstands strict scrutiny. The freedom to marry is recognized as a fundamental right protected by the Due Process Clause. The decision to marry is a fundamental right, and marriage is an expression of emotional support and public commitment. And then, new quote, the right to marry is of fundamental importance for all individuals. Okay, this court has long recognized that freedom of personal choice in matters of marriage and family life is one of the liberties protected by the Due Process Clause of the 14th Amendment. The freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. Quotes, and then open quotes again. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. End quotes. The parties do not dispute that the right to marry is fundamental. The question presented here is whether the plaintiffs seek to exercise the fundamental right to marry or because they are couples of the same sex, whether they seek recognition of a new right. To determine whether a right is fundamental under the Due Process Clause, the court inquires into whether the right is rooted in our nation's history, legal traditions, and practices. Here, because the right to marry is fundamental, the court looks to the evidence presented at trial to determine 1. The history, tradition, and practice of marriage in the United States, and 2. Whether plaintiffs seek to exercise their right to marry or seek to exercise some other right. Pretty important, that language right there, by the way. Let's carry on. Marriage has retained certain characteristics throughout the history of the United States. Marriage requires two parties to give their free consent to form a relationship, which then forms the foundation of a household. The spouses must consent to support each other and any dependents. The state regulates marriage because marriage creates stable households, which in turn form the basis of a stable, governable populace. The state respects an individual's choice to build a family with another and protects the relationship because it is so central a part of an individual's life. Never has the state inquired into procreative capacity or intent before issuing a marriage license. Indeed, a marriage license is more than a license to have procreative sexual intercourse. Quote, it would demean a married couple were it to be said marriage is simply about the right to have sexual intercourse. The Supreme Court recognizes that wholly apart from procreation, choice and privacy play a pivotal role in the marital relationship. Race restrictions on marital partners were once common in the most states, but now are seen as archaic, shameful, or even bizarre. When the Supreme Court invalidated race restrictions in Loving, the definition of the right to marry did not change. Instead, the court recognized that race restrictions, despite their historical prevalence, stood in stark contrast to the concepts of liberty and choice inherent in the right to marry. The marital bargain in California, along with other states, traditionally required that a woman's legal and economic identity be subsumed by her husband's upon marriage under the doctrine of coverture. This once unquestioned aspect of marriage now is regarded as antithetical to the notion of marriage as a union of equals. As states moved to recognize the equality of the sexes, they eliminated laws and practices like coverture that had made gender a proxy for a spouse's role within a marriage. Marriage was thus transformed from a male-dominated institution into an institution recognizing men and women as equals. Yet individuals retained the right to marry. That right did not become different simply because the institution of marriage became compatible with gender equality. The evidence at trial shows that marriage in the United States traditionally had not been open to same-sex couples. The evidence suggests many reasons for this tradition of exclusion, including gender roles maintained through coverture, social disapproval of same-sex relationships, and the reality that the vast majority of people are heterosexual and have had no reason to challenge or change a restriction. The evidence shows that the movement of marriage away from a gendered institution and towards an institution free from state-mandated gender roles reflects an evolution in the understanding of gender rather than a change in marriage. The evidence did not show any historical purpose for the excluding same-sex couples from marriage, as states have never required spouses to have an ability or willingness to procreate in order to marry. Rather, the exclusion exists as an artifact of a time when the genders were seen as having distinct roles in society and in marriage. That time has passed. The right to marry has been historically and remains the right to choose a spouse and, with mutual consent, join together to form a household. Race and gender restrictions shaped marriage during eras of race and gender inequality, but such restrictions were never part of the historical core of the institution of marriage. Today, gender is not relevant to the state in determining a spouse's obligations to each other or to their dependents. Relative gender composition aside, same-sex couples are situated identically to opposite-sex couples in terms of their ability to perform the rights and obligations of marriage under California law. Gender no longer forms an essential part of marriage. Marriage under law is a union of equals. Plaintiffs seek to have the state recognize their committed relationships, and plaintiffs' relationships are consistent with the core of the history, tradition, and practice of marriage in the United States. Perry and Steyer seek to be spouses. They seek the mutual obligation and honor that attend marriage. Zerillo and Katami seek recognition from the state that their union is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. Plaintiffs' unions encompass the historical purpose and form of marriage. Only the plaintiffs' genders relative to one another prevent California from giving the relationships the due recognition. Plaintiffs do not seek recognition of a new right. To characterize plaintiffs' objective as the right to same-sex marriage would suggest that plaintiffs seek something different from what opposite-sex couples across the state enjoy, namely marriage. Rather, plaintiffs ask California to recognize their relationships for what they are, marriages. Having determined that plaintiffs seek to exercise their fundamental right to marry under the Due Process Clause, the court must consider whether the availability of registered domestic partnerships fulfills California's due process obligation to same-sex couples. The evidence shows that domestic partnerships were created as an alternative to marriage that distinguished same-sex couples from opposite-sex couples. In regards to marriage cases, one of the core elements of the fundamental right to marry is the right of same-sex couples to have their official family relationship accorded the same dignity, respect, and stature as that accorded to other officially recognized family relationships. End quote. By reserving the historic and highly respected designation of marriage exclusively to opposite-sex couples while offering same-sex couples only the new and unfamiliar designation of domestic partnership, end quotes, the state communicates the official view that same-sex couples' committed relationships are of lesser stature than the comparable relationships of opposite-sex couples. Proponents do not dispute the significant symbolic disparity between domestic partnership and marriage. California has created two separate and parallel institutions to provide couples with essentially the same rights and obligations. California Family Code 297.5a, domestic partnerships are not open to opposite-sex couples unless one partner is at least 62 years old. California Family Code 297b5b, apart from this limited exception, created expressly to benefit those eligible for benefits under the Social Security Act, the sole basis upon which California determines whether a couple receives the designation married or the designation domestic partnership is the sex of the spouses relative to one another. Compare California Family Code 297 to 299.6 domestic partnership with 300 to 536 marriage. No further inquiry into couples or the couple's relationship is required or permitted. Thus, California allows almost all opposite-sex couples only one option, marriage, and all same-sex couples only one option, domestic partnership. The evidence shows that domestic partnerships do not fulfill California's due process obligation to plaintiffs for two reasons. First, domestic partnerships are distinct from marriage and do not provide the same social meaning as marriage. Second, domestic partnerships were created specifically so that California could offer same-sex couples rights and benefits while explicitly withholding marriage from same-sex couples. Example, California Family Code 297, Governor Davis 2001 signing statement, quote, "In California, a legal marriage is between a man and a woman. This domestic partnership legislation does nothing to contradict or undermine the definition of a legal marriage." The evidence at a trial shows that domestic partnerships exist solely to differentiate same-sex couples from marriages. A domestic partnership is not a marriage. While domestic partnerships offer same-sex couples almost all the rights and responsibilities associated with marriage, the evidence shows that withholding of designation marriage significantly disadvantages the plaintiffs. The record reflects that marriage is a culturally superior status compared to a domestic partnership. California does not meet its due process obligation to allow plaintiffs to marry by offering them a substitute and inferior institution that denies marriage to same-sex couples.